My name's Lauren Myers-Kaufmuller. I'm one of the lecturers in the Exoneration Project Clinic, and this is Jacqueline Picaro. She's one of our 3L students, and Erica Tietz is also here. She's one of our 2Ls, so they're gonna talk about their experience in the clinic this past year and a little before that, because Erica did the summer with us too. But basically, at the Exoneration Project, we represent people who have been wrongly convicted, so people who are innocent, never should have been convicted to begin with, largely. We do some resentencings and things like that for emerging adults or juveniles, things like that, just pro bono, helping other people out. But one of the really interesting things I think about the Exoneration Project, even among other innocence organizations, is that we represent people throughout the pendency of their case. So we do get started after they've been convicted, after they've done their direct appeal. So we're basically looking at a collateral attack on their conviction. So there's new evidence of their innocence that has come forward in some way. And so we look at the different claims, and we have classes where we talk about what these different claims are. So we have an actual innocence claim where we're looking at new evidence that would likely change the result at a retrial. We look at ineffective assistance of counsel. We look at Brady violations that the state may have committed. And in Illinois, we have a really special claim that we get to do because Illinois has a very dark history and is unfortunately, Chicago specifically is known as the false confession capital of the world because Chicago police officers were literally torturing false confessions out of people for decades. And we still have a number of these cases that we're dealing with, and Jacqueline's working on one right now where he's been in since 1981, and we're still dealing with his case involving some of these bad officers. So because of that, we have what's called a pattern and practice claim, where we're able to bring evidence that these detectives did the same kind of abuse, often literal physical abuse. So they were electrocuting people, putting guns in people's mouths, suffocating them with typewriters over their heads, holding them out windows, all sorts of horrible things that they actually, some of them learned in Vietnam, torturing people over there, and then brought it back to Chicago. When they started to get wise to this, because people were so horribly injured that they had to be taken to the hospital and all of this started to come to light, they started to get better about it. And so they learned how to hide the bruising, and they would use phone books to beat people because it would spread out the injuries, or they started to turn to psychological torture, which we've also seen some of that in the military too. And again, some of the bad officers learned all of this in the military and then brought it back to Chicago. So we have a lot of those cases where these detectives were doing this to literally dozens and dozens, if not hundreds of people, and also did it to our clients. So we have a lot of cases that basically show that this was their pattern. This is what they did to everyone, and we're able to show this kind of nexus in our cases to show that this is what they were doing in our case too. So a lot of our cases end up involving that because we work largely in Chicago or throughout Illinois. We do have cases in other states too, so we don't have to necessarily work in Illinois, and Jacqueline has a case that's in Arkansas right now, so that's interesting too. But we get involved and we basically do an investigation. So we go out on the street, we knock on doors, people who don't know we're coming, and hope that they'll be willing to talk to us, or even home. So that can be a slog sometimes, but it's very interesting, I think. We go to prisons to visit clients. We have a lot of prison calls with our clients because I would say 98% of our clients are still in prison. Sometimes they do serve out their sentence if they're not serving life, and we still stay on their case, of course, because they are still wrongly convicted. We research and draft post-conviction petitions to bring their claims to court. Students work on all of these aspects. We then go to court and litigate these claims. And so there are a number of steps in that process. There's oral arguments basically that are done. And then we have evidentiary hearings that are basically bench trials. So we have to present all the evidence. We have openings. We call all the witnesses. The state calls their witnesses. We do closings, and the students are all involved in that. And then hopefully we win, and the conviction is vacated, and a new trial is ordered. And so what's interesting about the EP is that we do the new trial. So if there is a new trial that actually happens, obviously we're hoping the state will drop it and not move forward with that. But we do that, and students work on the retrials. And we do, pretrial litigation, motions in limine, all of that. If we lose, either at a retrial or at the evidentiary hearing, we do the appeal. So that's also something that's unusual for innocence organizations, because a lot of them don't have funding for doing that kind of work. So some of our students work on appeals, although I don't think either of you worked on an appeal, but we do have students who do that. And so that's interesting too, because you get to learn how to do the opening brief, and if there are oral arguments in the appeals, and doing reply briefs and all of that. And I think that what we try to do is at the beginning of the year, whenever, or summer, whenever the student is getting involved, they fill something out that says what they would be most interested in working on. So if they want experience in investigation, if they want experience in legal writing, if they want in-court experience, then we try to tailor the cases we assign based on that. So we usually have about 12 students in the clinic, and then we have 2 students per case, because we think it's good to get that experience working with a team on a case, working together, figuring out, schedules, or divvying up what the workload is going to be. And it's also good, it helps to bounce ideas off of each other. And we also do that in class. So when we come together, we also do the 4 times a week, or not 4 times a week, 4 times a quarter meeting. So it's not every single week that you'll be meeting. It's usually on a Tuesday, 4 to 6, but we have, the students will be working together instead during that time. And obviously if there's an investigation, we're going out with them, or on a prison visit or anything like that, we are obviously involved in that. But we try to give a really holistic, well-rounded experience. When clients are released, we also, really are very involved in their reentry process, because it is very, very difficult, regardless of whether you're innocent or guilty. Whenever you're getting out of prison, everything is stacked against you, and that's why there's this revolving door that they talk about. So we have a social worker at the EP staff that helps with all of that, but we also try to help, and we have our clients come in and talk. And this year, when we had a couple clients come in, they were both on, well, at least one of them was on a band, because he had his conviction vacated, but the state was still saying they were going to retry him. They've since dropped the charges, thankfully, so he's fully exonerated, but he still had the band on, and so had all those limitations because he was out on bond. And another one still has his new trial pending. So try to get all of that experience, all of those clients to come in and talk, and obviously they're talking to their own clients, so I think it's a pretty good experience. But I'll let Jacqueline talk about her specific experience in the clinic.
Yeah, thank you, Lauren. So my name's Jacqueline. I am a 3L, and I've been with the EP for a year now. And one of the things that Lauren mentioned that I think is so incredible about the clinic is that you are operating within the post-conviction space, which is, as Lauren said, collateral to like the normal trial process. But you pretty much get to do everything that you would do in the trial process within the complex legal morass of post-conviction law in Illinois, sometimes other states, and federally too, which adds like an interesting and fun complication to like the legal reasoning that you have to do as a clinic student, and hopefully as a lawyer someday too, in the post-conviction space. And under the incredible guidance of Lauren, Carl, and Russell, our clinic supervisors, they really teach us and go through this complex system, because it's sometimes very difficult to understand and confusing, especially as a first-time learner. But aside from getting all of those tools of being on the ground floor, investigating, getting to talk to witnesses and in the situations that happened, sometimes at least in for my client 40 years ago, and also talking with prosecutors, talking with police officers, and just trying to get a better sense of what happened in the case. You also get to have these incredible interactions and build relationships with clients. So in one of the cases that I'm working on with my client, he's been incarcerated wrongly for the majority of his life. And you would think that that would affect an individual to the point that they would no longer be able to find joy in anything in life. But instead, he's taken that and made it his mission to love the law, even though the law has turned against him in so many ways. He has taken college classes. He just graduated from college with the Northwestern Prison Education Program. He is also studying for the LSAT, and he's excited for it, which I think is not something that a lot of us would associate with the LSAT.
And we sent him books to study that the students were very helpful, and what books would be helpful for studying, because they've been through it more recently. So he was very grateful.
Exactly. And with this client in particular, his case, as Lauren mentioned, involves not only police pattern and practice issues of many of the witnesses who were coerced into falsely confessing or falsely testifying in the trial, but it also involves a conflict of interest. You get to work on a variety of different issues within each case because we try to find every single weakness in the original trial case so we can advocate on behalf of a client in post-conviction. And so with my client in particular, his attorney that represented him throughout the trial process also represented the actual perpetrator of the crime in court at the same time. So obviously poses some issues that we all know would be detrimental to his representation of our client. So we are in the process of actually getting a hearing scheduled within the next 25 days, or no, within the next month, to have a hearing in front of the court to get him hopefully exonerated. And we've also worked with the governor as well, and he's now parole eligible. So you get to do a little bit of policy on the side too.
Yeah, we did a clemency for him, and so he was commuted to parole eligible. He's been serving life without parole. So that's exciting. In 6 months, he gets to go up for parole, and maybe he'll actually get out if we don't already win his hearing. And it is our time, but can Erica speak?
Please, yeah.
Super quickly about her case.
Okay, hello, my name's Erica. I did the clinic full-time last summer and asked to work on more cases with investigation and strategizing through this year. You work a ton on your legal research and writing through all of the steps in the case, but I've also really enjoyed getting to be creative about the strategies we bring. So for the client that I've been primarily working with, he was convicted in 2013 of a murder that there is no evidence against him other than one guy who recanted his testimony on the stand. But the judge still convicted him, he's still sitting in prison, and we just have a mountain of evidence that he is innocent, including that the crime was on video, it was medically impossible, we have experts to say so, and the real perpetrator confessed to a bunch of people, and now that the real perpetrator is dead, those people are willing to testify too. So we are working through the best ways to sort of fit into this narrow post-conviction criteria of the act in Illinois so that we can show the same judge who presided over the original trial, by the way, that he made a severe mistake. So it's really
and it was a bench
fascinating.
trial, so the judge was the one who convicted him to begin with, and we've did the way the post-conviction law works, you have to go in front of the same court if they're still on the bench, so that sucks. But we're hoping we can show him that if he had been presented with this evidence that it was medically impossible for him to commit this crime, he would have found differently. But we also, with that case, this is something I didn't mention, went to the CIU. We're going to the CIU also. So sometimes we try to do that if there is, an opportunity. Not all prosecutors are willing to talk about actually doing the right thing, but in Cook County, they sometimes are. So we're trying that route as well to see if it'll be a little faster. So we will stop because it is our time, but